Hello, good evening, and warm welcome at the Thinking Palette platform. We have started a new initiative that is simply explained, where the focus is on to turn the complex and confused concept into clear and simple concept. Now you can easily look there are two different cuttings of the newspaper. One is of March 13 and another is of May 38. This newspaper heading says that Andhra Pradesh government has brought an ordinance that has cut down the tenure of a state election commission. And this has been challenged in the Andhra Pradesh High Court. And recently, that is on May 30th, 2020, Andhra Pradesh High Court has asked the government of the Andhra Pradesh to reinstate the state election commissioner. Now, in this context, we will look into the constitutional provisions for the State Election Commission, and the importance of this topic is that it can be used as a case study where the government is basically taking the autonomy of even the constitutional bodies, and this can be used in GS paper 2 as an case study in your mains answer writing. Now, what is the constitutional position of a state election commission? The constitutional position of a state election commission can be understood from these two important articles. That is Article 243K Clause 1. This article says that superintendence and direction and control. Superintendence, direction and control of the election of municipalities and panchayat level local bodies will be done under the State Election Commission. Likewise, Article 243K Clause 2 talks about the tenure and appointment of the State Election Commission. Now, how the appointment and the tenure is being decided? It is being decided by the law enacted by state legislature. Now, my question is that how the State Election Commission is removed? He is removed in the same manner as the judge of the High Court. Understood? Now, moving into the incident which happened in the Andhra Pradesh, but before that, there was a similar case in 2007 in Allahabad. In Allahabad, what happened? In Allahabad High Court, there was a petition with the same issue where the tenure of the State Election Commission has been cut down. Now, the matter was challenged in Aparmita Singh Prasad case. Aparmita Singh Prasad case. In this case, Allahabad High Court has given the verdict that it is the power of the governor to reduce or to increase the tenure of the State Election Commission, because everything is being done according to the law enacted by the state legislature. So, the matter went to the Supreme Court, and Supreme Court has also not considered it invalid and has upheld the Allahabad High Court judgment in Aparmita Singh Prasad case. Now, the same thing happened in the Andhra Pradesh. Andhra Pradesh government has brought an ordinance to cut the tenure of the State Election Commission, and it was natural that it would be challenged in the court, and the Andhra Pradesh High Court has termed it void. Therefore, you can understand that the initial position of the court is changed in Andhra Pradesh. Now, what is the importance, or you can say, what is the importance of this topic when it is being asked in the UPSC? In there, you will have to mention the challenges to the State Election Commission, because UPSC may ask question by making a comparison between Election Commission and State Election Commission. So now, there are three important challenges. The very first challenge is lack of autonomy. Now, in here, we can give one more case study, that what happened in case of Maharashtra. In Maharashtra, State Election Commission, or you can say the election commissioner of the Maharashtra State Election Commission, tried to conduct the elections of the mayor, but he was not succeeded. And what happened? That is more ironical, that he was sent to the jail for the breach of privilege of the legislature. He was sent to the jail. Okay. Now, this is the issue of the lack of autonomy. Now, the second thing is lack of safeguards. And here, in lack of safeguards, you can easily mention Aparmita Singh Prasad case and the Andhra Pradesh bringing ordinance that can be used here under the subheading of lack of safeguard. Non-uniform. Non-uniform simply means that we have seen in Article 243K Clause 2 that the tenure and appointment is being decided by the state legislature. Therefore, the different state legislature can have different laws, and thus there is a non-uniformity which is very different from the election commission. These are basically the challenges to the state election commission. Now, what are the different suggestions? In here, you can mention the Kishan Singh Tomar case. In Kishan Singh Tomar case, Supreme Court has said that ACC has an equal status as Election Commission, and therefore its autonomy and its independence must be preserved. Just it is a directive, no one is following that. Second ARC. Second ARC has said that the members of a state election commission and the state election commissioner should be appointed by a committee comprising of CM, leader of opposition, and a speaker of the state legislative assembly. The Law Commission 255th report has said that we should provide secretariat, and not only secretariat to state election commission but also to election commission, because right now election commission also does not have secretariat. So therefore these are the different suggestions which you can put in your answer, and this can be a case study also, and this can be asked by making a comparison between election commission and a state election commission.